So I hope everyone have taken their tea break. So everyone is freshened up now. So let's begin with our event. The time to announce some of our guests who've been there. So it's Mr. Harsh Kaushik. Please have a big round of applause for him. We have Mr. Vivek Sehgal and Ms. Praveena Gautam. So let's have a big round of applause for our dais. I would request Mr. Harsh to please come on the podium and enlighten the audience with his valuable points.
Sorry. Thank you. Good afternoon, everyone. Firstly, it was indeed a pleasure and an enriching experience to listen to all the speakers before me. So thank you very much for that. And I thank NASCAP for giving me the opportunity to speak today. I can assure you that I'm conscious that, people who come before me, so all of you are full of wisdom by now, but on an empty stomach. So I'll be quite quick and brief in that sense. I'll be speaking on the IP protection regime in India very broadly and generally so that I can cover as much ground as possible and within the time granted to me. Now, just to put it very simply, imagine a world where you go out to buy a car and the first place that you go to, they say that we sell our car under the brand name Mercedes and it's priced at X lakh rupees. You say, okay, fine. You go to another place and they say we are also selling a car and it's by the brand name Mercedes, but we sell it under the price tag of X minus 20 lakhs. So you wonder, why is that? Then you come to a third place. They say, yes, we also sell a car, that's also Mercedes, but we are now selling it, say, for X plus 20 lakhs. When you ask each of them, what's the reason? Well, what's the reason for this price difference? They give you a variety of reasons, and you're left to wonder as to why, what am I supposed to find out? How am I supposed to find out why this particular car is priced in a particular way? So you have to conduct a detailed technical exercise to find out why should I buy this Mercedes or the other one. That's one scenario. Look at another scenario. Imagine you're listening to a song in Delhi and you like it very much. So you find out who the composer of that particular song is. You call up your cousin in Kerala. She's a music composer because you want to share this news with her. You tell her this song that you've heard and this tune that you've heard. And you say that, oh, there's this lovely song, and you share that song with her. And Pat comes the reply. She says, no, actually, this is my song. What you're hearing from composer A is just a little bit of tweaking of this song from what I have made originally. Let's think of another scenario. There's a pharmaceutical company which invests billions of dollars in a lab specifically focused to build a treatment for a drug which probably will cure cancer. And let's hope that they succeed. They start producing that drug. And over a period of time, the moment they enter the market, there are other drug companies who also come. And they say that we'll also produce the same drug. And they start doing that. The original company, which actually made the drug, is not able to sustain this competition. And they shut down. Broadly, what I'm trying to emphasize is that this is how our world may have looked like if we didn't have IP protection regimes right from the very beginning. There would have been chaos, and there would have been no protection for invention, innovation, or creativity. So on a fundamental level, what I'm saying is that it's essential that we first of all recognize that IP protection in any of these areas, be it patents, be it copyright, trademark, trade secrets, whichever way you look at it, it is essential for any nation, and it is essential for any economy to function. Now, the more you speak about IP protection, and its importance can't really be overemphasized. Look at it this way, that even at the time when we just became independent, apart from looking at very basic laws of essential commodities, one of the other laws that came into being as far back as in 1958, and we had a law even before that for trademark, was the Trademarks Act. So while a nation is grappling with recently becoming independent and fix its laws, it chooses to also have a trademark protection law. This is how important IP protection has been for any nation which has started building right from the beginning. Now, if IP protection is an essential cog in any nation's economy, India being no different, it's essential that we continue to improve and ensure that the regime that we have in place is in accordance with the international best practices, and we are able to ensure that it gels well with the mood of how people are choosing to protect their IP internationally as well. I mean, this word globalization, we have heard more often than not, but it is so true that in a world where there is convergence of technology and there are businesses which are, of course, transcending borders, and like, for instance, today's topic, that the concerns that the US government may have regarding the IP protection regime in India, and they conduct such a detailed exercise to find out in so many countries, India being one of them, as to how the regime is in India, demonstrates that countries across the world who want to invest in another country would want to know, would want to be apprised of the fact that they're sure that when they enter this regime, they're able to protect their IPs, and which I see no reason why we should shy away from the fact that we can learn as much as we can from whatever information comes our way. What we adopt is a choice that we make, but there is no harm in getting that information from any source that it may come from. Now, very briefly and broadly put, I would say IP protection regime in India, I would say under, say, three heads, if I may say that. One would be the initial stage when you do the registration aspect of it, in the sense that you go through a statutory process, be it under the trademark law, be it under patent law, and you are able to protect your IP by going through that registration process. That's the first facet, as I understand. And I'll touch upon only 2 and 3 of them because of the given time constraint. Now, if I were to touch upon the issues that people face, say, for instance, in the trademark sector, if I may say, regarding the registration of trademarks, more often than not, the complaint that we hear is that the oppositions are not being decided expeditiously. So that's an area which I believe we must look at very carefully. Recently, some positive steps have been taken. Around 30, 40 officers have been employed recently on a consultant basis by the registry itself in order to designate them as hearing officers and to ensure that all opposition backlog is cleared very quickly. This is an area which I believe we must look at and we must work at very hard. Similarly, in the patent registration process, if I may say, there has been lack of predictability in the way we decide and in the way the adjudications come out from the patent office. And I'm not talking about courts right now, where I practice, fortunately or unfortunately. But that's a predictability in decision-making and precedent. It's essential for people who apply for patents and who want to understand what their course is going to be, their journey is going to be, the timelines within which they'll be able to obtain a patent. All these things need to become more predictable. Of course, there has been considerable improvement. There is no question about it that a lot of effort has been put in. But I would still say that given the pace at which we are moving, and if we want to increase that pace, the pace of improvement also has to increase. Copyright registration, of course, is an area we really not delve into too much, and I won't because that's not an essential facet or a characteristic which is emphasized in India at least. If you want to protect your copyright, there are means available for you to do that, which really usually is through the adjudicatory process rather than through a registration process. The second aspect, very quickly, I would say, or the second head, which is essential, is enforcement. Enforcement is another area which I believe we need to focus a lot more on. We are very inclined either towards registration and we are very inclined towards adjudication in courts of law. The middle, if I would say, in the middle comes the enforcement part, which I believe is very, very important because it will reduce the burden on the adjudicatory process. What I mean by that is counterfeiting and all other areas were touched upon by the other speakers. Our investigative agencies and people who are employed to ensure that counterfeiting or piracy is curbed is necessary, according to me, in the sense that people who are involved in the investigation and who are made to participate with trademark owners or with other rights owners must be equipped and must be trained more in all the laws that are there. Half the time what happens, and these are issues that people face, is that the investigative agencies, although they are very cooperative and overburdened, if I may say that, but the expertise required, the resources required and are not available with them. It leads to a situation wherein while their intentions are right, while the attempt is being made, however, because of lack of resources and lack of some amount of expertise, the issues are not taken seriously. For instance, there was a point in time when cybercrime was not that serious an issue even in our current setup. But today, if you look at it, there are cyber crime cells in each of the districts today. Even in the remotest districts, sometimes you find cyber crime cells, specialized police officers, specialized agents who are employed by the police department in order to tackle cyber crimes. I am emphasizing today that it's important that we look at other kind of IP protection, for instance, for trademark, copyright, wherein similar cells, if possible, of course, resources permitting, are put in place in order to ensure that there is expertise and that people are ensuring that when they go to these investigative agencies, there are good and possible and probable and good outcomes coming out of these actions that they may take in order to protect their rights. The other aspect of enforcement, of course, is that when people have private agencies and private associations in order to help them to conduct enforcement of their rights, it's essential that even the state machinery cooperates with them, because these investigative agencies ought not to be seen as some kind of affront to the state agencies who are otherwise supposed to conduct these raids, if I may say, or other enforcement mechanisms. So it's essential that there is some amount of camaraderie and some amount of working mechanism that is built between these enforcement agencies which may be operating at a private level and enforcement agencies which operate at the state level. Presently, according to me, there is no such setup and there is a vacuum. So people are then left in the lurch, because even though they are able to, say, conduct investigations and produce reports in order to enforce their rights, ultimately when they want to go to the state agencies to make sure that penal consequences entail upon people who are indulging in violation of rights, the state agencies usually do not cooperate. And we are then back to square one and start from the beginning the whole process which the agency, private agency, would have conducted on its own. So enforcement, as I said, is another aspect, both at the level of the expertise that is available with the state machinery and the fact that there has to be greater coordination between private agencies and government agencies is another aspect I suggest we look at very strongly in order to improve our IP index. And maybe the next time when we meet, the report would have a higher ranking for us. Third, of course, is an aspect which I believe awareness, IP awareness right from inception. Now, there is this startup boom that we say India is going through, and we are having these new businesses come up and all, so on and so forth. What we don't realize is that sometimes, insofar as the IP protection aspect of that is concerned, the process seems to be in the reverse. People start their business, they build their brand. Once they've become popular, that's when they start realizing, oh my God, I have to protect my IP, I have to protect my trademark, I have to protect this process. According to me, it's essential that MSMEs or small businesses, or for that matter, startups, are educated right in the beginning. It's essential for them to realize that when they start their business, that is the time when they have to protect their IP, right at the beginning. And it's not that costly. I mean, while there may be a perception amongst people that, oh, why would a small business invest in protection of IP right at the beginning? That, I believe, is not a correct perception to have. The IP protection available in India, be it trademark registration, be it patent registration, the whole entire process is not that costly. It may be a bit cumbersome, which we can work upon, but the process is not that costly. And that's why it's essential that awareness about IP protection right at the inception for startups or for businesses, I believe, is an essential aspect we must look at, and the government would do better to educate startups in that department, I suggest. Another aspect that I would say, and the last aspect which I would cover, would be the adjudicatory aspect. And I closely work in that area. I'm a practicing lawyer by profession and happen to practice a lot of IP law. Now, there are very good and powerful measures which have been taken, I would say, at least in Delhi. But I don't know whether that's enough. But considering that I practice in Delhi and I go to other courts as well, I can surely say the creation of the IPD division, which Mr. Raghavinder mentioned, the fact that experts are being engaged in order to assist the judges, these are very, very good positive steps which are being taken in the adjudicatory department as well. Because it's, judges are human beings, and it's not as if that every judge is trained in a particular complex patent dispute. I mean, half the time even people who come from that industry would struggle to explain why a particular compound is there in a particular drug and how is it to be viewed when you're looking at it from a perspective of if there being a patent dispute between two pharma companies. So these are really complex issues. So judges would definitely need assistance. So in the adjudicatory department, I would strongly suggest that hiring of experts and assistants to courts by those experts is essential. Any country who is looking to invest in India will always look at the adjudicatory process that that country provides for. For instance, I'll give you an example. Arbitration as a process, while we have had an Arbitration Act for a very long time, but the pace at which it used to progress was literally at a snail's pace. Sometimes amongst lawyers we used to joke that sometimes the civil suits in a court is being decided faster than what an arbitration would lead to. Now that's not a scenario we should be comfortable with. That's why it's essential that the adjudicatory process, especially in commercial disputes and Commercial Courts Act, which again Mr. Raghavinder pointed out, is a very good and positive step that we have taken in that direction. So even in the adjudicatory process, it's essential that we, one, give expert evidence and assistance of experts to our judges, because that's essential for them to be able to take a decision faster, and more importantly, to take a decision which is commercially viable and which has commercial orientation attached to it. Deciding commercial disputes in abstract or mainly or as a matter of rights, as I said at the beginning, would lead to a chaotic scenario. It's essential that even judges realize that when an entity is choosing to come to court, essentially what it is protecting is its commerce. And that's why they also need to be commercially oriented in their decision making. Of course, public interest has to have a essential role to play in that. One aspect that I would like to point out is that, which is very close to the adjudicatory process, but a step before, and which is the last aspect that I'll touch upon, as I believe, overstaying my welcome here, but I'll be quick about it, is the legislation that we come up with. Now, just to be on the lighter side, I mean, we sometimes take the wrong lead from other countries as well. There is a act in US which came some time back. It's the Digital Millennium Copyright Act. Now, because I practice a lot of copyright law, I can share with you at the time when that act came about, when I read about it, I was feeling, is this pro-technology or is this act outcome of great lobbying in the US? I mean, I couldn't really fathom the difference between the two. So what happened was MySpace used to be at the time a very big thing in US as a website. So a particular copyright owner here in India chose to sue MySpace in the Delhi High Court. And it's a landmark judgment. I had the privilege of appearing for that copyright owner in that case. So I won't be biased though today in my opinion. And you know, one of the things that happened was that MySpace went so far ahead so as to take Digital Millennium Copyright Act as a defense in the suit in India. So we had to remind the judge that, I mean, as much as MySpace would like to be covered by that act, we are really here in India and we have to be governed by the Indian Copyright Act and not really what the Digital Millennium Copyright Act provides for. So, I mean, there are things, and this is just on the lighter side, but there are things that sometimes you see in other countries and you end up adopting them, which is what to an extent has happened in India now. Portions of the Digital Millennium Copyright Act now do find an imprint here. There are judgments which have actually followed what that act provided in terms of protection to certain kind of websites. I, for one, do not know whether that's good or bad for business. Only time will tell. But I do believe that that fundamentally cuts across what copyright protection provided for. So there are websites today now which justify that, which is the other side of the coin, which we must look at as well, that if you were to not recognize that, then you are literally against technology. Because what those websites are actually doing is latest technology, they may say, that they have come up with. They have ensured that content is available across the board freely to so many people. And these are answers which can't really be underscored. I mean, a judge has to balance both the aspects. But yes, I do believe that that's why it's essential that we look at these aspects on a holistic level and adopt them accordingly. Another aspect which I do believe, and that's the last thing that I would say, is that legislation should be clear and direct. I believe that some of the things that have happened of late, as some of the amendments, I must say Mr. Raghavendra is not here, but I would like to commend him actually for bringing in the amendments which brought in rights, publishing royalties for the authors and composers. There are people who died in penury when their songs were making millions and those monies were not being distributed to them. So it's a very, very commendable piece of legislation which came in 2012, personally, I believe. But then there is another side to the same amendments, which I personally believe went a little further, which is the statutory licensing aspect under Section 31D, which now literally provides, simply put for the audience here, that if you are a copyright owner and if your work has been published before, a broadcaster like a radio broadcaster or a TV broadcaster, and now there is debate regarding whether even internet broadcasters are covered by that, can simply play your works, send you a notice, and you will get paid basis the royalties determined by a forum, that is the High Court now, which was earlier IPAB. Now that copyright owners really feel has went a little too far, because they believe that the copyright that they create or the content that they create is their labor of love. So at the heart of the copyright law is protection of exclusivity and the fact that I've created it, so I should be allowed to exploit it as I deem fit. That essentially seems to have been taken away. That's their argument. But these are again aspects which need to be looked at, and that's why I say legislations, when they are being drafted, I do believe wider consultation and ensuring that stakeholder interests are protected and there's a balance that is struck between all is very, very essential for any government. So at the end, I would like to conclude by saying that if we want to be sure that when we go and buy a Mercedes, we know that we are actually buying a Mercedes, or when we listen to a song, we are sure about the composer who's actually made that song. And when we buy a medicine and we want to be sure about the fact that this medicine is coming from a particular source, it's essential that we recognize that IP protection is critical. And I, for one, would always commend any country who wants to invest in India and would welcome them. And whatever criticism they may have or whatever comments they may have, I would take that as feedback. And I'll implement it to the extent possible and the way I deem fit. But I would certainly encourage them to share that information with us. So the report 301, as it is called, we'll wait for a report in 2023. And I hope the next time when we meet, as I said, our ranking is much, much better. Thank you very much.
Very well said, sir. Thank you so much.